291 DP. If council could please place their appearances on the record.
John Danielski on behalf of Mr. Bargy.
Thank you.
Sorry, I'm having a little difficulty with my camera for some reason. If the court could just give me one moment, please. Oh, there it is. Excellent. All right.
All right, then we have Ms. Stoke. On behalf of Ms. Capelli.
Yes.
All right, we're getting feedback from somebody. Hopefully that stops now. All right, we're here today on two matters. There's a show cause regarding custody parenting time complaint, as well as a motion for the children to be interviewed in person. We are set for an evidentiary hearing next Wednesday. When that matter was set for a hearing, neither party had counsel. So I'm willing to listen to any arguments on whether that anything should happen in person. So Ms. Doke, it's your request that just the children be interviewed in person, or that we do the whole hearing in person?
Is the hearing scheduled for? It's not scheduled in person?
I think it's scheduled by Zoom.
I
believe it was in person.
I guess I have always assumed, well, I think it would be better to have it in person. I always think that the evidentiary hearings go better in person. It's just a lot easier to do.
So when it was scheduled on November 1st, again, the parties did not have counsel, and it was discussed whether to be by Zoom or in person. At that point, they said they were okay with Zoom, so it was set for a hearing by Zoom. We can certainly change it to an in-person. I think when there's counsel involved and there's a request that it be done in person, if there's not a stipulation that it be handled by Zoom, then I would do it in person. So are you at this time, Ms. Doak, requesting that the hearing be done in person?
Yes.
Okay. Mr. Danielski, do you have any objection or any response to holding the entire hearing in person next week?
Well, I've got a cabin 10 miles east over in Joburg. I mean, if I have to come up there, you know, I can do it. I mean, I think my client would prefer it to be via Zoom, but I did check my schedule. I could drive up Tuesday night. I even told him I got an extra room. He could stay there, and I think it's scheduled for the afternoon at 1 o'clock, I believe is the time. And then I could just drive back. I got hearings I need to be in Thursday, but I could just drive back on Wednesday night. So I'd prefer it be via Zoom, but I heard what Your Honor said. So I guess I'll just leave it at that and leave it for the court to make a decision.
All right, thank you. Yes, so it is the policy that when there's not a stipulation by both parties to do it by Zoom, it would be held in person. Unfortunately, it sounds like we can continue it with that date that we have next week. So what we're going to do is require that this hearing be an in-person hearing, as well as then the children would be interviewed in person, so they should be brought up also. I'll start my interview with the children at 12:45.
Your Honor, I would ask
Yes.
then if on the show cause, if we could deal with that next week as well. We might as well deal with everything next week.
Correct. I was going to get to that too. I was going to say that we'll deal with the show cause during the evidentiary hearing. My understanding, there was another recent parenting time complaint filed. I think it was mailed out yesterday to the parties. Ms. Doak, were you aware of that other recent filing? Were you part of that, or did your client handle that on her own?
My client filed that. I haven't seen it yet.
All right. In front of the court, is it correct that that was mailed out yesterday to Mr. Bargy?
Correct.
Okay. So my thought would be we could probably address those issues also, because I think they're all part of the same. Address those at the evidentiary hearing. But Mr. Danielski, when you get that document, if there's truly an issue of not having enough time to prepare any arguments on that document, I would give you additional time, but I'm assuming it's all interrelated, so I think we can probably handle everything at the hearing next week.
Sounds fine to me, Your Honor. I guess my client will. The kids, they get school next week. I guess they're going to probably miss a day of school, right?
They'll be missing school.
All right. Well, it is what it is. So we'll figure out how to get them up there and have them interviewed, Your Honor.
Thank you, Counsel. I appreciate your cooperation on that matter, and we'll see everybody here in person next Wednesday.
And Your Honor, how long do you have set for that hearing?
We are set for 3 hours.
Okay, so that's
DC.
okay. Great. Thank you so much.
Thank you. Mr. Cadet, are you here on that matter?
Yes, good morning, Your Honor. Courtney Cadet on behalf of Cassandra Ingersoll, who is present separately via Zoom also.
Thank you. I don't see Mr. Ingersoll present or his counsel. I know we did recently set this matter for a hearing, as well as the parties entered a temporary order. The hearing was set for January 2024. We're here today on a show cause that was filed by Mr. Ingersoll. I'm not sure if he ever let his attorney know that this was pending or not. Mr. Cadat, anything that you would like to say on this matter?
Just that we'd request that the court not hold my client in contempt of court, Your Honor. As Mr. Ingersoll indicated in his show cause motion or his parenting time complaint, my client was the victim of his assault, for which Mr. Ingersoll was arrested. The way he phrased it was, she had me arrested, as though she was the aggressor, but her bruising and black eyes and so forth from the incident would show otherwise. Because Mr. Ingersoll was in jail, and there was a no contact order almost immediately entered for him not to contact my client didn't have communication from Mr. Ingersoll as to his availability to exercise any parenting time. As soon as my client did get communications through a third party, since Mr. Ingersoll couldn't contact my client did resume scheduled parenting time until Mr. Ingersoll went to jail again shortly thereafter, incidentally, while he was exercising parenting time with the party's child, resulting in the party's child having to be removed in an emergency situation back to my client.
Thank you. Well, given Mr. Ingersoll's failure to appear, as well as his attorney's failure to appear, there was also no request to adjourn this matter and no request to consolidate this matter with the evidentiary hearing, which is set for January 17th. Given those factors, I am going to dismiss the show cause against Ms. Ingersoll.
Thank you, Your Honor.
Thank you. You're all set. 665 DS. Parties can please identify themselves. Looks like Mr. Walker is connecting to audio. Ms. Singleton, can you hear me okay?
Yes, I can, Your Honor.
Thank you. All right. Looks like Mr. Walker has connected to audio. So, sir, could you please unmute? And can you hear me okay?
Yes.
All right, I'm here.
All right, we're here today on a petition filed by a friend of the court regarding a request. It appears to review the accounts, make any necessary adjustments based on the parenting time. It looks like the friend of the court did go through and do a quite thorough review, and now has some proposals regarding a tiered support modification and order. Friend of the court, can you summarize kind of the status of where we're at on this matter?
Yes, Your Honor. The front of the court director, Catherine Vogt, completed an investigation, and then at the conclusion of that, presented the Otsego County front of the court office with the proposed changes, which are laid out in the petition to redirect support to the parties providing the actual care for the child pursuant to the various guardianship and NA orders that existed during throughout the history of the case. So that led to two uniform support orders. The first one has 4 tiers to redirect support to third party David Fox for periods where he was providing care for the child, and then back to plaintiff at the appropriate times. And then finally, the second uniform support order abates support pursuant to the existing custody and parenting time order in January of 2022. During the investigation, the front of the court director did conclude that there were periods where support was redirected appropriately, so there was no need to include those uniform support orders in the proposed changes.
All right, Mr. Walker, did you receive and review all those documents?
No.
You talking to me?
Oh, yes, sir. Sorry, I'm talking Mr. Levi Walker.
Okay.
No, I did not. I was actually informed of this meeting by my dad, who you just heard, because he contacted me and had questions, and I didn't receive anything. I actually had to call the front with this meeting information.
All right. So are there periods where you're saying you had custody of the child?
June of 2020, June 17th of 2020, I picked my daughter up from the airport under the premise that she was coming to visit me a couple weeks. She then decided she wanted to stay. and then she was with me.
Until when, sir?
The exact date, I'm unsure of. She lived with me. Then once I knew I was going to have her full time, we then moved to my parents in Ionia, Michigan, or Fenwick, I think it is. We moved. I knew I was going to need help. That I worked full time. It was going to be a situation where she needed to have some type of supervision, as well as them help her with her, day-to-day life. And I was unavailable. My mother is retired.
All right, well, sir, so right now I'm just asking about dates. So all the stuff that happened while I was with you, I'm not overly, what we're trying to establish is other dates and orders that show she was living with you. So at that point, you wouldn't be paying support.
Yes. David Fox gave me guardianship and power of attorney in July of 2020. And then there is an order in Montcalm County on the date that ended, because she stayed with my parents to finish that year of school, then came back to stay with me after that year of school was out.
All right, so you're saying in July of 2020 you had the custody?
In July of 2020, I have guardianship and power of attorney papers signed and dated, as well as with a seal on them from David Fox, placing in my care.
Right. And when did that care terminate?
On the date in Montcalm County, when they transferred that over to my parents, so my parents could make all necessary decisions for her, being that she was living there until she was finished with school.
Do you know when that date was, or roughly when that date was?
I honestly do not.
Your Honor.
I want it.
March 31st, 2021, I believe.
The front of the court have paperwork that shows at some point that Mr. Walker, he mentioned his orders, he says transferring the guardianship to him. Did Miss Votes into her investigation to reveal that document, or was that provided to her?
That was not provided to her.
So Mr. Levi Walker, do you have that document you referenced?
Yes, I do. I have it on my phone. I tried to email it to the email address that was provided to me, and it's not working, as well as the emails that he's tried to send me recently so that I could email him back. I never got.
All right, so what we can just do is verify with the other parties if that's accurate or not. It's kind of a history of where the child was, but the parties, if everyone's in agreement, we don't necessarily need the actual paperwork and document. So, Mr. Levi Walker, you're saying in July of 2020, you received the child from David Fox?
Actually, June 17th of 2020 was the day I picked her up from Grand Rapids International Airport, and I had her all the way up until March, whatever day that was.
And in March of 21, where did she go?
She was with my parents until August of that year.
Your parent, Brian Walker?
Brian and Christine
Yes,
Walker.
sir.
Okay. All right, Mr. Fox, could you unmute, please? But while that's happening, Brian Walker, is that accurate then that the child came to you in March of 2021?
Yes, sir. That's when I received guardianship, total control over her. Court up here in Montcalm County. Yes, but they were living with me in July, the middle of July, up until she went into my son moved to Kalamazoo. She stood with me, and then that following school year, of her last school year, she did a week or two here in September of that year, and then she wanted to live with her dad down there in Kalamazoo.
So is it accurate? Do you think it's accurate that she was living with Levi then in June of 2020
Yes,
up
sir.
until that time where you then had the guardianship. Is that correct?
That is correct, sir.
Okay. Mr. Fox, I see that you are unmuted now. Can you hear me okay, sir?
Yes, I can.
All right. Did you hear the discussion we've been having about that time frame of June or July of 2020?
Yes, sir, I did. All
right.
I did fly her from South Carolina, where she was living with me, to Grand Rapids to spend 2 weeks with Levi. At that point, there was nothing said about her moving there permanently. We were in Michigan, and he and Skylar came to my folks' house, and that was when Skylar informed me that she wanted to go back south, or back north, actually, with her father. And that was the first that I had heard about it at that point, as far as her wanting to go and stay with him and be there permanently. The only thing that I gave him was a power of attorney so that he could get her into school and things of that nature. I never gave him guardianship. He had to go to the friend of the court or to probate court or whatever he needed to do to get that, just the same as I did to get her in the very beginning.
Okay. But is it accurate then that once she came to Michigan, she then stayed with Mr. Walker and did not return back to you? Is that correct, sir?
Yes.
Okay. All right. And I'm a little unsure. So, I mean, obviously we have this, we know that in June of 2020, child then was with apparently Mr. Walker. Ms. Singleton, do you agree with that?
I do, Your Honor.
Okay. So what then we need to figure out is when that sort of time ends. So front of the court, do you know then?
So the proposed change would have been from June 17, 2020, effective until, or then that would have ended March 31st, 2021, because effective April 1st of 2021, there was a support order and is a current in the file for Mr. Walker to pay his father, Brian Walker, $265.
Okay, so that period would be abated. There'd be no support charged during that period.
Correct.
All right. All right, Mr. Levi Walker. So that's verified then that the child was with you for that time period. So that support period would abate. Was there another time period that we needed to address?
Yes,
Okay, what is that time period?
that is the time period starting from when she came back to stay with me after she finished out her school year. It was like the second week of school up until almost the end of school when she went back to this. She was almost 18 when she went back to her mother's. And I had her almost the whole school year.
I missed the year. What year was that?
That would have been her senior year of high school. I believe it was 2022.
She graduated in 2022, but she came back to stay with me at the end of 2021. Her 18th birthday is February 1st, and she came back home before then.
All right. For the court, do you know when support completely stopped in this matter?
Yes, Your Honor. A zero support order entered effective January 14th, 2022.
So, sir, Mr. Levi Walker, are you saying in the fall of 2021 the child was with you?
Yes, sir. That's my parents. My mother actually called me and informed me some difficulties dealing with Skylar, and we thought it was best that she come back and stay with me because my mother, in dealing with health, epilepsy, just said it wasn't beneficial for her to be there.
Were you living with your parents, or you were living separate from them?
No, I own my own home in Kalamazoo.
Okay. So you're saying in the fall then of 2021, Skylar was with you.
And I enrolled. Yep, and I enrolled. And she finished out her last year.
Ms. Singleton, do you agree with that? That Skylar was with him in the fall of 2021?
In November of 2021. It was before the holidays that she came back home. I believe the guardianship paperwork hearing for Chris and Brian was terminated November 3rd of 2021.
Okay. I do see that the guardianship was terminated 2021, November 3rd.
For
So,
Chris and
was there
Brian.
was there any support that was charging after that time period?
After November 2021.
Yes. What's it?
I believe we will need to, I believe that's one of the proposed changes needed. That would, yeah, so tier 4 of the proposed changes would be effective from November 4th, 2021 to January 13th, 2022. And will cease charge paid and abate support owed to Brian Walker as an order entered on 11/3/21 terminating this guardianship.
Mr. Brian Walker, in
Yes,
2021, when did you stop having custody, or when did she stop living with you?
Why she stopped living with me? She was having complications with attitude.
Not why, sir. Just when did that happen?
Oh, when did that happen? Okay, that happened in when she moved out of my house and with her father. That was then sometime in September, and I continued with guardianship on her through the court system and petitioned the court to have that removed and appointed it to Levi, and that was in November. And
Okay.
Levi had a court. He was up there in court in Montcalm with them, and the judge granted him guardianship.
Okay.
When it was removed from me, it was placed back with her father.
All right. But she was not living with you as of September of 21.
Correct. She
Correct.
was living with her father.
All right. All right. Mr. Levi Walker, do you agree with that? Then we can make that change starting in September of 2021. Then there would be no support charged against you.
Yeah.
Okay. All right. Mr. Levi Walker, do you think there's anything else that needs to be addressed regarding these time periods?
Yes, my biggest question is, in the beginning, when she was removed and put in David Fox's care, all of that time that she was with David Fox, I should have been paying David Fox. I shouldn't have been paying. I should be responsible for any of the state assistance that I'm paying back to the state that's coming after me for towards Jamie. My responsibility is to Skylar. Any of that child support should be towards Jamie Fox or towards for those time periods. It is not only not fair, but it is also not right that she benefit from her child being placed in someone else's care by your county because of whatever was going on with her at the time. I believe that, like I said, my responsibility is to Skylar, and that to me makes absolutely no sense. Would be being paid or would be eligible to be paid child support, or that I would be on the hook to the state for child support that should have never even been going to her in the first place. Then my second question about that is there is an order of me paying child support to my parents for the time that she was with my parents. Why is it that Jamie wasn't paying child support to my parents? It takes two people to take care of a child. So if I'm have to take responsibility for those times, I believe she should as well.
All right. Well, I mean, certain things are kind of probably too old to change and get into at this point. We were kind of making sure we have the right issue as to who the caregiver was at this time, which I think we've kind of squared up. So, front of the court, do you agree now that we've got a picture of who the child was with and when?
Yes, so there will be an additional USO to go with the two proposed ones for the abatements based on what we've heard today, and then the proposed redirections and everything will go into effect for when David Fox was primary caregiver. So yes, I think we have everything mapped out for a timeline.
Okay. So what we're going to do is we're going to prepare new orders. There will be a right to object to those, Mr. Walker. But step one is to make sure we get where the child was at and with who first. And then after that is prepared, you'll have another chance to file an objection if for some reason there is a reason, grounds to object based on where we're at once we get the correct location of who was providing the care for the child. Do you understand that, Mr. Walker?
I do. And I have one last question for you. I informed Luann Dean, who was my caseworker at the time, not only in writing of everything as to what was going on, and nothing was done. I guess you're now telling me that it is too late to do things, and I've given support plenty of time to redirect all of these things, as well as I've went through the necessary steps and nothing was done. So I guess I guess at the point I'm at now is if you're telling me it's too late and I'm going to be the only one that's having to take responsibility for this, and I guess that's just Otsego County letting Jamie off the hook again, I will be seeking in an attorney, and we will move forward at that point, because I also know that one of the judges that signed an order against me, Judge Morris, was also her attorney in the very beginning, and that in itself is against the law and a conflict of interest. So I've already been speaking with attorneys, as well as I do work professionally through the city attorney of Grand Rapids, and she's the one who's directed me to do so. You guys are doing
all right. So that will be helpful then if you could get that filing in. What I said is it might be too late. Again, I don't know the whole history of all of this matter, but we're going pretty far back in time. But that it sounds like they've kind of gone back and done some looking and checking to see where we're at. I'm not sure what happened with who got ordered to pay the support and who didn't get ordered to pay the support. And obviously this goes a long way back as far as these orders, but we're going to make those changes as to where the child was and with who, and make sure you get your appropriate periods of abatement. That documentation will be sent to you with the option, the ability to file an objection for anything that is not accurate. And then perhaps then you can also address the other motions that you'd like to file along with those based on the conversations you've had with an attorney. That certainly, you're certainly always free to file any appropriate motions that you want to and can. Okay, sir?
Yes.
All right. Any of the other witnesses have any questions or any comments that they would like to make? All right, so the front of the court will prepare those new support orders, and we will go from there. Any other questions from the front of the court?
I got it. Thank you.
All right, thank you everyone for appearing. That does conclude this matter.
Thank you.
Can my daughter sit in with me?
Ma'am, we'll address that when we call your case, okay?
Okay, thank you.
I do see we have Ms. Curry present. Is Kevin Curry present? I see one individual labeled simply as a Zoom user. Could that person please unmute and identify yourself for the record?
Angela Schultz. I'm trying to change my name.
Okay. All right, so you don't have Mr. Curry yet.
Did he need to be present? I can contact him.
Yes, he does.
Sorry. Yeah, my oldest daughter got a hold of him and she gave him the information to sign in.
Okay, thank you. All right, so we have a phone number in the Zoom area that is muted. Could that person please unmute and identify themselves?
Dad, is that you?
Say that I didn't hear.
Okay. Do you?
He's having problems getting into the Zoom meeting.
Do you have Zoom up?
Yeah, I had it up, but it kept flashing in and out. It wasn't a constant picture, and then it went digital, and then it froze up, and then I pushed it. It showed a button. I can't remember what it said. I pushed it.
All right. We're good. I can hear him there. So just keep the phone by Ms. Curry. We can handle it that way.
Okay.
All right. So Mr. Curry, can you hear me? No.
Try again.
What is Mr. Curry's phone number?
1 second. I can get it to you.
I just want to make sure he wasn't one of these other numbers I've got in our room. Yes.
Can you hear?
Kind of.
All right, Mr. Curry, can you hear me okay?
Yeah, if it's all right with you, I'll have Allison, my daughter's there, kind of translate if I don't understand.
Okay, so we're here. So for both Mr. and Ms. Curry, we are here today on this matter was set before the court following an ex parte order that was issued to address what is the plan as far as custody and parenting time and support. So Ms. Curry, I'll ask you first. Do the two of you have any agreements right now as to how you're handling custody and parenting time?
Well, presently I am living in his house with my oldest daughter and my youngest daughter.
You're living with Mr. Curry at this time.
Mr. Curry is residing at his parents' house in Gaylord at the moment while she stays here.
All right, so the ex parte order granted Mr. Curry physical custody. So at this point, there's no set standard parenting time agreement. Does there need to be one at this time, Ms. Curry?
I don't believe so. I mean, it's parties agree.
He wants to know if there needs to be set parenting times, like schedule.
No, I'm not.
Well,
No, don't need to worry about that. That's what we're doing is working, so I'm not going to change it.
Mr. Curry said he does not want to change any agreements.
all right, so what we can indicate is the parties are having parenting time as the parties agree. So we can make that what the current order says. And then when issues arise, or if issues arise, either party can file a motion to set a specific parenting time schedule. Are you okay with that, Ms. Curry?
I am.
All right. And Mr. Curry, are you okay with a parenting time schedule that says it is as the parties agree?
Repeat it, Elliot.
Are you okay with keeping the custody agreement as it is?
As parties agree.
As parties agree. No, the parenting time as parties agree.
Parenting, yes, I do. The parenting time, fine.
Okay, he agrees that the parenting time is fine the way it is as parties agree.
Okay. For the court, do you know the status regarding child support in this matter?
Mr. Curry was the payer and it's currently set at 0.
Okay. Ms. Curry, do you have any, or either one of you, I guess I'll start with Ms. Curry first. What is your request regarding child support? It is currently set at 0.
I'm not requesting any child support.
All right. And we need to find out if Mr. Curry is requesting any child support.
Are you requesting any child support, Gab?
No.
Mr. Curry's statement is no.
All right, I did hear his answer.
Okay.
Okay, so I think all we need to address then is based on the referral from the court that granted the physical custody to Mr. Curry at this time. It will indicate that at this time the parties will have parenting time as the parties agree. Any questions, Ms. Curry?
I do not.
All right, and does Mr. Curry have any questions?
Any questions, Gab?
No, I have no questions.
No questions.
Okay. All right, thank you. That does conclude this matter. You're free to sign off. Parties present.
Thank you.
This is a friend of the court hearing to address parenting time, custody, and support. Ms. Shannon is the plaintiff, so I will ask her first. Ma'am, do the two of you currently have any agreements on those issues?
Yeah, we do.
All right. And what is your agreement?
We want to do joint custody 50-50. And as far as parenting time, he gets the kids from Sunday 11 a.m. until Tuesday between 3 and 4. And he also takes them every other week from Sunday 11 to Wednesday till about 5:30. And then basically if there's like a free weekend, like where if there's something going on to where he wants to take the girls, then, you know, he just says, hey, this is going on this weekend. It's okay if I take the kids. And, you know, we're very flexible as far as that goes. We still do holidays together and birthdays together. So we don't split holidays. We don't split birthdays. We do all of that together still. And as far as child support, I do need some form of child support because I am on state aid, but I'm not trying to make him go broke either because whenever I need anything, he helps me. Right now he's paying for my heating bill. He pays my phone bill. If ever I need any extra money or anything towards the kids, he just hands it over, no questions asked. Most of Christmas has been provided by him this year. He's, you know, bought most of the Christmas gifts this year for our children. So I don't know what the minimal amount of child support is for me to receive to where I can stay on state aid, but if we can do that, you know, I'm not trying to, I know, you know, I'm not trying to be unfair, not trying to, you know, break the bank or anything like that, you know.
All right, thank you.
If that
So
makes any
my
sense.
understanding then is, so 1 week he gets 3 overnights and the next week he gets 4 overnights. Is that correct?
Yeah, yep.
All right. All right. And Mr. Shannon, do you agree that that is the terms of your agreement?
Yes.
All right. So you're asking the court to enter an order that grants the parties joint legal and joint physical custody. Is that correct?
Yes.
And dad's parenting time would be 1 week, it would be Sunday at 11 a.m. until Tuesday afternoon between 3 and 4 p.m. And then the following week, it would be Sunday at 11 a.m. until Wednesday at 5:30 p.m. Is that correct?
Yes.
And the two of you are going to handle holidays as the two of you agree. Is that correct?
Yes.
And do you feel this agreement is in the best interest of your children?
Yes.
Then as to child support, what's going to happen is a child support recommendation will be prepared. You do have the right then, both parties have the right to object to that recommendation, but one will be calculated. You both have a chance to look at it and then potentially file an objection if you want to argue or attempt to have something different as far as the child support is concerned. And sir, are you asking this court to enter an order that grants the two of you joint legal and joint physical custody?
Yes.
And your parenting time would be Sunday at 11 a.m. until Tuesday between 3 and 4 p.m. And the following week, it would be Sunday at 11 a.m. until Wednesday at about 5:30 p.m. Is that correct?
Yes.
The two of you are agreeing to handle holidays as the two of you agree?
Yes.
And you believe this is in the best interest of your children?
I do, yes.
In front of the court, do you have the financial information for these parties yet?
No, we don't.
All right. So both of you, you're probably mailed packets. If you no longer have those, you would need to let front of the court that know that, and they can send you new packets or you can come pick them up. But you do need to comply and file that financial information within 21 days so a child support recommendation can be prepared.
Okay.
Ms. Shannon, do you have any questions?
I do not.
Mr. Shannon, do you have any questions?
I do not know.
All right. Thank you both for appearing. That does conclude your matter.
I think.
Thank you.
Mr. Tubbs, could you please unmute and let me know if you can hear me okay?
Yes, I can hear you. Good morning.
All right. And Ms. Doak, please place your appearance on the record. Ms. Doak, can you please place your appearance on the record?
Can you hear me now?
Yes.
Jody Doke appearing on behalf of Taffia Wood.
Thank you. We're here today for a review hearing. Ms. Doak, as counsel for the plaintiff, I will hear from you first. Any updates, thoughts? Where is this matter at this point?
So I don't know if friend of the court is aware of this or not, but the judge is conducting review hearings as well. And so we had a review hearing in front of the judge. Neither party had received the order that the judge entered, and it looks like FOC didn't receive it either. Because when I was on the record with the court, I was like, we don't have an order. And he said, I did enter an order and it was sent out to everybody. And then it was set for, that it should be reviewed or whatever. And so Mr. Tubbs hadn't received the order either. So then we all got that order and the parties are supposed to be compliant with that order. And then the court set a review hearing in February after that. So I mean, my opinion, for whatever it's worth, is that the review hearing should either be conducted by the court or by friend of the court, but not by both, because that would just lead to confusion. But that's my take on it. We can do a review hearing if that's what you want.
Well, I do see now that you put that out, there's a review hearing. It appears in front of Judge Mertz on February 5th.
Correct. And he had one before that. Yeah.
Okay. Mr. Tubbs, any questions or comments or anything that you would like to say?
No, not really. I really just had a concern about the hearing being all the way out in February. I was just a little confused because it got bumped up like 4 months. That's all I was concerned about.
Well, I do see that order's in there. In front of the court, anything that you would like to say?
No, Your Honor.
All right. I mean, I think if Judge Mertz has set this matter for a review hearing, it would make sense for that to continue. So for our purposes, we will not take any testimony or review the matter. This matter is set on the judge's docket for February 5th. But thank you to the parties and everyone for appearing today. I see Mr. Carncross is present. Sir, can you hear me okay?
Yes, sir.
All right. And then there's another individual who's muted. I'm not sure if that's Miss Carncross, but whoever that person is, could you please unmute?
Yes.
Are you Miss Carncross?
Yes.
All right. Thank you. All right. We're here today for an initial hearing regarding custody, parenting time, and support. Ma'am, you are the plaintiff. I'll ask you first. Have the two of you discussed those issues, and do you have any agreements regarding custody and parenting time?
Yes.
Okay. What is your agreement?
It's 50-50, sorry. Trying just to it's 50-50 custody agreement. Like no one's having more the kids more than the other.
All right, so you're agreeing to joint legal and joint physical custody, is that correct?
Correct.
All right. Do you have a specific parenting time schedule, or do you just simply work on that as things go along?
We work on that as a team as things come along.
Okay. And as to holidays, are you agreeing to share holidays, or are you asking for a specific holiday schedule?
Nope. We are doing shared holidays.
Mr. Carncross, do you agree that is the agreement?
Yes, sir.
Okay. So in that case, I'm going to put you each under oath and then ask you some additional questions. So Ms. Carncross, I'll start with you. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, ma'am. So is it correct that you're asking the court to enter an order that gives the parties joint legal and joint physical custody, and that parenting time would be as the parties agree?
Yes.
And you would also agree that the two of you will share holidays as the two of you agree?
Yes.
And that the goal here is equal overnights, is that correct?
Yes.
Okay. Have the two of you had any discussions regarding child support?
Yes.
Okay. And what discussions have you had regarding child support?
You want to take that one, or you want me to?
Well, first let me start with this question, I guess, ma'am. Do you receive any state aid, or do the children have any aid?
So I do get state aid. The children are getting state aid, but I'm requesting for no child support. He's got insurance for the kids. It won't start until January 1st, and then we're taking the kids off of state aid, so child support doesn't have to be implemented. Enforced.
Okay. All right, I understand. And ma'am, do you believe this custody agreement is in the best interest of the children?
Yes.
All right, thank you. All right, and sir, are you also asking the court to enter an order that gives the parties joint legal and joint physical custody?
Yes, sir.
And that parenting time and holidays would be as the parties agree?
Yes, sir.
And do you feel that's in the best interest of the children?
Yes, sir.
All right, so as to child support, what the court's going to do, we do have to prepare a child support recommendation. The parties can then object to that if they seek something different. And that might also give some time for that to process, and then to see state aid longer effective, because there does have to be some type of support if there is state aid. Have the two of you submitted your financial information to the friend of the court yet?
Not yet.
I didn't.
Okay. So I would order that you provide that information within 21 days. If you no longer have that paperwork, please contact the friend of the court to have them mail you new paperwork or come by to pick that up. So a child support recommendation be prepared. You'll have 21 days to object to that. So if you get that and the two of you want to do something different, you can file that objection, and then we will address that at that time. Okay?
Your Honor.
Yes.
If he has the children enrolled that will start January, if he could provide that information, then I can look at that possibly for potentially 2 tiers after the first of the year.
Okay. So yeah, Mr. Carncross, when you do provide the information, if you can also provide who their insurance is going to be through and that information. Yeah, I know it doesn't start till the first, but if you could provide that information in advance, that would be helpful.
Yes, sir.
Okay. All right. Thank you both for appearing. You will get a copy of the court's order from today, as well as then a support recommendation will be prepared, and you need to make sure you provide that financial information. Thank you.
Okay, thank you.
All right. We're here today on a motion filed by Ms. Parrott Gauthier regarding pairing time. Ma'am, what is it that you are seeking to change?
Well, before I filed the order, I was seeking help because if I were to text or call Adam, he would not respond whatsoever, even over something as simple as a library book that was missing from school. So I would just I'm requesting an order that there be communication between Adam and I in regards to Adeline. And if there is a third party involved, I think it should be someone appointed by the court. I don't think that there should be a third party in my household making parenting decisions or anything like that. Like if Adam wants Adeline on my week, he should have to come to me and vice versa. I don't think that there should be a third party in my household or his involved in parenting time decisions or parenting decisions at all, since we are the parents. And I'm also requesting co-parenting classes because we really struggle to co-parent together. And I think that that would be very beneficial for Adeline in the long run, so that we can learn how to co-parent in a healthy way for Adeline's sake. She's been really struggling in school the past couple weeks. We had a sit-down meeting with her teacher. She has been to RTC 3 times in a row, and she has been lashing out. She hit a teacher at school. And I think that that really shows that we really do need help co-parenting.
So the current order is that it's shared, it's joint legal, joint physical with week on, week off. Is that correct?
Correct.
And
However,
you're not looking
sometimes
to any of the parenting time. Is that correct?
No, I'm not looking to change that. But sometimes if he wants her for an event that he's going to do, or for instance, last Saturday, it was my week and his mom goes to Florida for the winter and he wanted to take her on my Saturday so they could go visit his mom before she left for Florida. And I just think that decisions like that need to be made between the two of us, not between a third party outside of the two of us within either home. I think if I want something, I should go to him. And if he wants something, he should go to me. I don't think a third party needs to be involved unless it's the court, since we are the parents.
Well, and there's nothing in the order that says third parties are to make those decisions. Obviously, you are the parents need to make those decisions. I don't think we need to add anything special to the order. If he has a third party communicating with you, you can choose just not to have that communication. Mr.
I've tried that though.
Mr. Becker, what would you like to say?
Your Honor, the only third party is my girlfriend, and she has been a part of Adeline's life since I believe she was 2 years old. And other than my girlfriend, there is no other third party, but she is just as much in Adeline's life as me and her mother. And sometimes it takes a colony to raise a child. But other than my girlfriend, it's just we have worked on it. We are getting better at it. I'm not opposed to co-parenting classes. But we actually sat down, like she said the other day, and probably for about 4 hours, we all discussed so we can all be on the same page for Adeline.
Well, what do you have to say about communication? I mean, obviously, I think issues regarding Adeline, that as far as communication between the two of you, should be something that is communication regarding Adeline is something that should happen between you and Ms. Gauthier Parrott, as far as, concerns that are going on, as far as, changing up the schedule.
Correct. And I agree with that. But I work 2 jobs. I work a full-time job at Alta Equipment, and then I plow part-time Meyer. So when it's snowing, I'm not around, and she is with my girlfriend. So sometimes I'm not able to make the decision because I'm not there.
Well, what decisions are we talking about that are of a concern?
This is my thing. So if when he took Adeline for that Saturday, I had planned to go to the Magical Reindeer Farm down in Clare that Saturday. So I called him a couple of days ago and asked if I could take her on his Saturday, this coming Saturday. And he said that I had to ask Maddie, his girlfriend. And I just don't understand why I have to have communication with her when that's his child. And she has not been very nice to me. So if I don't want that negativity in my life, I shouldn't have to deal with that.
Well, you don't necessarily have to. But, when each parent has the child, what goes on in that house is, what that parent decides and how things happen. Communication, should be between the parents when it comes to switching times and those type of things. But if he's, at work and can't have a discussion, then I would just have to wait till later. I guess I'm not seeing any presented though to the court that anytime a parenting time order is changed, there has to be proper cause or change of circumstances. I don't see anything that rises to the level at this point that would show the court should have an evidentiary hearing on these issues. This is some pretty basic things that it sounds like Mr. Becker has acknowledged he's trying to change that communication issue and be on the lead for the communication. So, ma'am, is it accurate that you've had a conversation recently and discussed these issues with him?
That is correct.
Okay. All right. So at this time, I'm going to deny the motion. I don't believe at this point that there's any proper cause or change of circumstances that warrants revisiting the parenting time and custody order. I'm not going to order the two of you.
That's not what I was after.
All right, tell me what you're after, man.
I wasn't after trying to change the parenting time. I just wanted an order stating that we had to communicate, because before I filed this motion, there was no communication. He wouldn't respond to me at all.
An order would be a change. So you're asking for a new order. So a new order would be a change to the current order. We don't get. The court doesn't get so deep into everyone's lives to discuss how every communication should go. I mean, if there are glaring issues with communication, then you can certainly bring this motion back to the court, and then we would readdress it. But based on this record, I don't think there is proper cause or change of circumstances that warrants a new evidentiary hearing on the issue of parenting time.
Like I said, Your Honor, I don't mind. Like I said, we are working on our communication, and I believe it's getting better. So
I still think parenting classes would be beneficial for Adeline and both him and I.
Well, it sounds like you both are agreeing to do that, so you can certainly do that.
Okay, but I don't know how to go about that. I don't even know where they are.
There are lots of co-parenting classes available online, some good programs. So I think if you do a search, you'll find some programs that you can both look at and talk about and agree to take. And obviously it's more beneficial, I think, if you take the same class.
Right.
That way you're getting the same information and can work together. But there are several classes that you can find online.
And like I said, I'd be willing to do that just so our communication, ultimately, Adeline is, I don't know how to say this,
she's the one to benefit out of it.
Correct. So
I'll do that. So based on the parties' agreement, I will indicate then that the motion regarding parenting time is denied. However, the parties are in agreement that they shall complete a co-parenting class. I'm going to leave it to the two of you to go online and find which one that you think works best for you. But you shall complete that class within 60 days. If one of you doesn't, then we'd have to address that.
Sounds good to me.
Any problems with that? Okay.
No,
All
Your
right.
Honor.
Thank you for appearing. I hope the communication can continue to get better, and I hope that class is helpful for both of you. If not, like I said, you're always free to file any motions to readdress the issue if it continues to happen. Thank you.
Thank you, sir.
Thank you, Your Honor.
All right, thank you. We are here today for an evidentiary hearing on the plaintiff's motion to change parenting time. An order was signed by Judge Mertz, looks like on September 18th, following an evidentiary hearing regarding custody and parenting time. Mom has now requesting to change that order. Is that correct, Ms. Racky?
Yes, Your Honor.
And what provisions or how are you looking to change the order?
I would ideally request that the court drops the Zoom calls and and the visitation.
Okay. All right, so since there is an existing order, the first step is you have to show that there is proper cause or change of circumstances that warrants revisiting the prior order. If there is no proper cause or change of circumstances, then the court is not able to make any changes. If there is proper cause or change of circumstances, then the court would review the appearing time factors as well as the best interest factors to determine if any changes should be made. So, ma'am, since this is your motion, we will start with your testimony first. This is your opportunity, ma'am, to present your argument as to why the order should be changed.
Your Honor, on October 16th, that was, I'm not sure if you remember the last hearing, but I was 15 minutes late as that was tax filing extension deadline date. I was 15 minutes late for our Zoom call and he called me and I immediately picked up the phone and I said, "Oh my God, Doug, I'm so sorry." You know, and I was prepared to do the Zoom call and he immediately started screaming at me. And then on October 19th, he sent the Zoom link at 8:06, so he was 6 minutes late, and then he hung up after 5 minutes and didn't even tell me. So I'm standing there holding the phone and I haven't heard from him since.
There's been no Zoom calls since that October 18th date?
No, Your Honor, we established in the very beginning when the Zoom call started that he was to send me the Zoom link at 8 p.m. Eastern time because he needed to send it from his tablet. He was unable to send a link from his phone to his tablet for some reason. So that was what had been established between us, and I have not received anything since October 19th.
Mr. Brown, do you want these Zoom calls or not?
Yes, Your Honor, I do.
Okay. All right. All right, Ms. Radke, you may continue.
Well, that's pretty much it. You know, I've spent every Monday and Thursday at 8 p.m. for 15 minutes because I think 15 minutes is reasonable to wait for a link. And I have not received anything. And to me, it's a waste of my time. And there's really no benefit to River. He doesn't understand what's happening right now.
You also indicated you wanted to stop potential pairing time visits if you were in Michigan. What argument do you want to make regarding that?
Because he's a severe alcoholic. So at the very least, I would request supervised visitation, which I did request in our very first initial hearing.
Okay. And what has changed since that hearing regarding the visits? Does he have any visits since then?
No, he's not had any visits. He has not communicated about wanting any visits. And after reading the order, I realized that the supervised visits was not there.
So as to that request, there was a recommended order that was put out with an opportunity to object. There was no objection. So I don't find there's proper cause to revisit the supervision issue because there's been nothing to show that anything has changed since the order went into place. But I guess I do want to hear from Mr. Brown regarding Zoom. I may have gone one step too quick. So Mr. Brown, you do have the right to ask questions of Ms. Radke since she provided testimony. So before I ask for your testimony, do you have any questions you wish to ask her?
Due to the fact that our son is nonverbal, when it comes to these calls, is it acceptable to ask Ms. Radke how my son is doing since he cannot communicate that with me?
All right. So my first question to you was, do you have any questions you wish to ask her?
Do you have a question for Kobe? No, I guess I do not.
Okay. So if you've got no questions that you wish to ask her, then the next thing to do is for you to provide your testimony. What would you like to say in response to her request to stop Zoom calls, as well as to stop any, as well as to require well, I've already ruled on the request to do supervised visits. So as to her request to stop Zoom calls, what would you like to say?
The only reason I have not done the Zoom call is after hearing all these allegations from February, I actually turned myself into a 30-day in-house rehab. So I've been dealing with that. That is the reason I have not contacted her, and the fact that I got served. So I didn't want to mess up the PPO. I was unaware of how that whole thing went down. But that is the reason so far, Your Honor, that I have not called.
Do you intend to call in the future for these Zoom calls or not?
Yes, Your Honor. I absolutely do.
It would seem reasonable that if you weren't going to exercise the calls for a while or take a break from them, that you would at least provide her notice so she's not waiting for you to make the call. Don't you think that would be appropriate?
Yeah, but I got the the protection order, so I didn't know. Yeah, because in the paperwork it said that I cannot contact her, that I couldn't do any of these things. So I didn't want to mess up the opportunity with seeing my son.
Well, do you believe you're able to contact her now or not?
Yes, Your Honor. Yes, Your Honor, I do.
Is it accurate that there is a current PPO in place, though?
Yes.
But that PPO does allow you to have some type of contact when it's related to the custody order. Is that correct?
Yes, Your Honor. Yes, Your Honor. I didn't know that until I got out of the rehab. They were trying to serve me while I was in there, and I didn't find out about any of this until I came back home. But now that I've read through it, yes, I do, Your Honor.
So are you able to resume the Zoom calls?
Absolutely.
What do you think is the best way to make those happen? Because what I want to avoid is, which we discussed before, was just avoiding, I think a set time is appropriate, but is it accurate that you would send a link to her or that you're calling her? How is the best way to handle this?
I can definitely send a link. I can do that.
All right, and it's 5 o'clock
Pacific time.
It's 5 o'clock Pacific and 8 o'clock Eastern.
Yeah, that is actually what Kobe asked for. I've tried to contact her before due to the fact that River hasn't been sleeping, or she's unavailable at the time. So I've been trying to I've contacted her before, trying to see if we could make it a little bit earlier or whatever. I'm just going for immense convenience. I just want to co-parent. That's it. I think it's.
Okay. Is there anything else you want to say, sir?
Is it okay to speak with her to see how my son is doing, to the fact that he does not talk? Like schooling, potty training, anything like that I believe a father should know about?
I would have to leave that to her. There's nothing that in the orders that obligate her to have conversations with you. There's the issues of the PPO. So that would be, I think, her call as to what kind of information she intends to share at this time. Ms. Radke, what are your thoughts on a good time for these calls?
8 o'clock is really the only time. And Your Honor, if I could please have a stipulation in there that it does not disrupt his schedule. He's autistic, so sometimes he stays up really late and sometimes he's passed out by 7. And I work full time and have 3 kids. And I don't necessarily have time to do it earlier than that because that is the time that we're settling down.
So is 8 o'clock better than 7:30, you think?
8 o'clock would be the best time for me. Yes, Your Honor.
All right. Yeah. And that's what intent was of the, so when I look at the order right now, though, it said 5 p.m. Eastern, but that's a mistake, correct? It's supposed to be 8 p.m. Yeah. Eastern, correct?
Yes, Your Honor.
And you agree with that, sir, correct?
Yes, sir.
May I add something, Your Honor?
Sure.
He was just served with a PPO on December 7th. So, and I haven't heard from him in almost 2 months. So even the 30 days and the PPO just being served not even a week ago, there was no excuse to leave me hanging like that.
Mr. Brown, what do you want to say regarding that?
I was not aware of any other PPO. The only thing I've gotten is what I got exactly when I came back from when I got back from the rehab, sir.
Okay. All right. Anything else you'd like to say, Ms. Radke?
Oh, you know what? No, actually, I'm sorry, Your Honor. I did call on the day I was supposed to go to rehab, and then you guys wanted us to do an in-house, and there was no way that I could make it to Michigan. So that is what we were talking about.
Your Honor, if I may, that what happened with that particular PPO hearing was that he had ample opportunity to request to appear via Zoom and waited until the day before he was required to appear to request that.
All right, ma'am, anything else you'd like to say regarding your motion?
You know, if the Zoom calls need to stay, I would request maybe once a week instead of twice a week. It is a lot for me.
All right. Anything else? Mr. Brown, anything else you'd like to say?
Yeah, I don't understand how 5 minutes is asking too much. I don't agree with that at all. I mean, this is my son, and the only thing that I get is 5 minutes, and I truly believe that that's not a big.
All right, thank you. All right, so the parties are before the court based on the plaintiff's motion to modify the current pairing time order. The order was signed September 18th of this year. The motion itself was filed September 18th of this year. But Ms. Radke has pointed to some things that have happened since the filing of the motion that causes her concerns regarding the Zoom call. There was a period of time, apparently now, there was an application for a PPO, which has been granted. That PPO does allow for contact related to the child and the court-ordered custody and calls. However, it does say the respondent can have contact for exercise and parenting time, that during those contacts, he cannot engage in any threatening, harassing, frightening, or abusive behavior toward Ms. Radke. So there is now a provision an additional provision that really provides Ms. Radke with cover should Mr. Brown not behave appropriately during the calls. Not only could she file a motion regarding the phone calls, but she could also file a PPO violation. So given that provision, I don't believe at this point there is proper cause or change of circumstances that warrants a review of this recent parenting time order. There simply has not been enough that has happened that would at this point justify changing or canceling those calls. If Mr. Brown continues to not exercise those times, and certainly that might create a new situation where changing the calls would be appropriate, or if his behavior is not appropriate during those calls, then certainly there would be potentially a reason to revisit the order and make changes. But at this time, I don't believe that burden has been met. I will indicate, though, that the last order actually was set at 5 p.m. Eastern, and it's supposed to be 8 p.m. Eastern Standard Time, 5 p.m. Pacific Time. So I will make sure that this denial of the motion does indicate that, however, that portion should be changed based on the stipulation of the parties. They agreed it should happen at 8 p.m. I'm also going to add, though, that Mr. Brown, if you're not going to be available for the call, you just need to shoot Ms. Radke a simple message that you are not going to exercise your call that day.
I understand. Is there any way that could go both ways, Your Honor?
Well, when you call, if she's not going to be available, yes, she does need to let you know, and there needs to be a makeup time. That's standard for any type of phone call. If the child is sleeping, she doesn't have to necessarily let you know in advance. She can let you know when you reach out to her that the child is sleeping or is unavailable, but then she would also need to let you know when that can be made up.
Okay, because there's been plenty of times where I've tried to make up
All right,
dates.
sir. We've addressed that issue. Ms. Radke, do you understand that?
I understand, Your Honor.
All right, thank you. All right, thank you both for appearing. That does conclude this matter.
Thank you, Your Honor.
Here today, there was a custody case filed. It also included an ex parte request. That ex parte was denied. The matter was then set before the friend of the court and then scheduled for a evidentiary hearing to address the issues of custody, parenting time, and child support. It's my understanding there's never been any prior orders regarding those matters. Is that correct, Mr. Wood?
Correct.
Okay. All right. So then we will just jump right into the testimony unless the parties have an agreement. Is there any agreement that the parties have, or do we need to proceed with the hearing?
There's no agreement yet.
All right. So this is your chance then to provide your testimony in support of your position regarding custody. But let's start with that. What are you asking for in particular when it comes to the custody and parenting time in this case?
For her to be with me during school week. I want 50-50. I'm not trying to try to fight to take my kid away from her. I just want 50-50, but I would like to have her here during the school weeks.
Okay.
And like
So
holidays, we switch holidays and all that. That's, you know, she gets her 1 year. We do that now. Like she got her for Thanksgiving. I get her for Thanksgiving and all that. I want all that to stay the same. But when she's in school, I would like for her to be here and her mom on the weekends.
Okay. All right. Thank you. All right. So now you may begin your testimony regarding this matter and what you'd like to say to me in support of your case.
Yes. I ever since she's been with her boyfriend, she will not communicate with me. She always communicates with my girlfriend. I'm the father. Everything should be communicated with me first. She's failed to get her at doctor's appointments. I have records from the school of last year while she was in Caitlin's care. She has numerous absence of school. I got it all record. Because she couldn't get up or something happened where my kid did not get to school. And here, my daughter's on a schedule. We're on a eating schedule. Everything is scheduled. I think she does better in school when she's here. Another thing, I've paid for almost everything that has to do with doctors and stuff for my daughter. I just paid $3,000 for an expander in her mouth. I asked her mom to help me, and I found out her mom won't help me is because I never made her. She wasn't the decision making in her mouth, my daughter's mouth. Well, the dentist is the decision maker. I went with what the dentist said that my daughter needs to straighten her mouth out. So I went with it, and since I didn't involve her, she says she's not obligated to pay that payment. She don't take her to a doctor's appointment. I've taken her to every doctor's appointment. Most of them. She did a few years ago when she was married to Taylor. But now it's like she can't talk to me because of the boyfriend. She's not allowed to talk to me. She does talk to me here and there, but when I ask her questions, it comes back that she don't answer the questions I'm asking. It's always about something else. My daughter has come here wearing her underwear, her clothes. My daughter don't need to be walking in public wearing clothes that are oversized. And why would you let your daughter wear your used underwear? I've had to throw a couple of them away because I'm not washing them. Her hair's a mess, like she hasn't showered. And it's just, I'm in the safety of my daughter's. I want her to be clean. I want her to go to school every day. And it seems like when I put her in that care over there, it don't happen. And for my daughter just to sell in life, there has to be some kind of structure. And all I'm asking is, like, during school, I don't want to change nothing. I'm not trying to get her from her. I'm not trying to keep her from her. But I think that she's more suitable with me instead of her mom. And that's what I'm going to go on. And that's what I'm going to fight tooth and nail until the end of this court date. I have proof on all this. So.
All right. Well, the notice to this hearing indicated that if parties have any evidence they want to submit, that should be provided a week in advance. Have you submitted any exhibits to the court or to Mr.
No, because I wouldn't have came here by myself because I want to get an attorney in this matter. Because I'm not a kind of person that can talk on my behalf because I'm not good at that. And I didn't really want to represent myself anyways. I thought this was the first step to getting a court date to go to court. Just like the other day when I was a witness in Taylor, he was in the courtroom. Why am I getting Zoomed here? Because I got a bunch of witnesses.
We were here on October 4th. And that's when we said we asked if there's any agreements or if we needed a hearing date. We set the hearing. We indicated that hearing would be by Zoom. That notice then was mailed to the parties that indicated the hearing was by Zoom, that there was a 3-hour evidentiary hearing was set for today. And if you wanted to present evidence, you needed to provide that in advance. So,
right.
I guess
I'm still waiting on police report too.
All right. Well, first you
I do
started
want
off
to say.
with now you're saying you want adjournment. So I'm going to address your adjournment request first. I mean, you've made the adjournment request the day of the hearing, and after you already provided some testimony. This matter again was set for a hearing back on October 4th, with notice being sent. It looks like October 10th. So as the request to an adjournment, I'm going to deny that request at this time. But you can proceed. You can continue with your testimony, sir, regarding your matter.
Yes, I also want to say that she is in a relationship with an unstable man. When I left your courtroom 2 days ago, he and Caitlin and my daughter got into the van, and he took his van with my daughter inside of it and ran into my truck and tried to push my truck into a parked car beside me. I had to call the police when I left your office the other day to have the police write out a report because I'm pressing charges because that's child endangerment for having my kid in the car while you're slamming into my truck. I don't want my daughter around him. He's threatened me. I just made a police report. I just called his PO today. His PO is going to have him come in and talk to him because I'm tired of the death threats. I'm tired every time when I go to do something matter with my daughter, he has to open his mouth. It's none of his business. He had to be removed from my daughter's school a month and a half ago because he wanted to be there thinking he has a right to tell me that that's his sister and he can be there when he wants. The cops had to show up there and remove him. He's dangerous. He needs help. He's unstable. And like I told the cops today, I've been calling numerous trying to get these reports because the cops haven't got back with me on the hit and run that I filed. What happens if he's already put his hands on her? I got proof of it, that he's choked her, he smacked her. What if he snaps and kills him? Who's going to be responsible for that? Are we going to have to wait till it's too late? I mean, I'm feared for my daughter being around my own son. He is a very menace to society right now. He is unstable. The cops had to come out of the courtroom the other day to tell him to shut his mouth numerous times, and then they had to call back up to keep an eye on him at the end of the hall. I don't want my daughter around him. He tells her to shut the fuck up, excuse my language, but he tells my daughter to, when he's mad at Caitlin, he talks to my daughter like an adult, and it's not right. And I don't know what I can do. I got a PPO on him. I mean, I don't know what else I can do to keep him away from my daughter. I got proof that he's unstable. And this is why I'm in court today against her, because until she leaves that guy, I'm going to be taking her to court every time I get a chance for my daughter's safety. I do not trust her around him. I don't. I got proof that he threatens everybody that he talks to that comes in contact with Caitlin Gibson. And if the police reports don't do anything, I don't know what else I can do.
So any more testimony you want to provide, sir?
No, sir.
Do you have any documentation or any exhibits that you wish to provide?
I do have it's on my phone, so I probably can't show it to you, but I do have the police report where he had to leave the school and they got a trespassing thing on him. I have text messages. I just don't have copies because I thought this was just going to be a hearing to get this all set up. So that was my misunderstanding. Because I would have had this attorney to take this matter over.
Well, do you not remember being in court last time? Did you not get a notice that says? Okay.
I understand the court proceedings, but I thought this is because I just filed for the custody that you had to go through a hearing first and then you're able to get set up to go further. That's what I was. I thought this was like a hearing to set a court date for the actual matter. So like I said, that was my misunderstanding.
Okay.
Because if I would have not,
we had that court date. We had the court date where you're all right that there is always an initial hearing to set the matter for a hearing. So we had that hearing back on October 4th. And we said we were setting this for a 3-hour evidentiary hearing. And that's right on the court notice. So I think that's pretty clear that we were here today to take testimony and address these issues.
Right. And like I said, that was my misunderstanding and I'm taking all responsibility for that.
All right. Thank you, sir. All right. Is there anything else you'd like to say as far as testimony?
No, thank you.
Ms. Dewey, do you have any questions for us?
No, I do not.
All right. Mr. Wood, I do want to get some just general background information. When was the last time that you and Miss Dewey resided together?
Oh God, 6, 7 years.
Okay.
Or more. I don't know. I don't remember.
All right. After you separated, what has been the typical custody arrangement for your child?
We went through a mediation because we agreed on certain things. And at the time we went to mediation on the agreements, I was working a lot and I was a single father, so I didn't have a babysitter. So we agreed for Kylie to be at her mom's during the school week and me on the weekends. Well, that's all changed now. I have time to be here for my daughter during the week, and I do have a family. I got 2 other kids and another baby on the way, so I have the means to keep her here. So when we went to mitigation, that's what we agreed on at that time because of my situation. Now that I don't have to have a babysitter, and I do work, but I still have somebody that is a stay-at-home mom and is here. I want it changed because, like I said, I have proof of when she was in her custody last year. The school reports show that when she was at her mom's, there was tardies. Her mom don't like when her mom keeps her from school, she never calls the school because the school calls me and says, why your daughter in? So I have to excuse my daughter because she can't do it for some reason. And I tell her all the time, you have to call the school and let them know. If not, it's a tardy and it affects my daughter. So therefore, I think she should be here because she lives all the way in Mansalona. What happens if she can't get up in the morning and she's decided to take Kylie to school? Guess what? My kid suffers because her mom don't want to get out of bed and take her to school. And it has happened like that.
All right. So back to my question. You said at one point she was primarily with mom during the school week, but at some point that changed. So did you guys start doing week on, week off at some point?
I think, no, this is the first year we've done the week off, week on during school. It's like in the summer, it's like 2 months on, or we were doing 2 weeks on, 2 weeks off in the summer, or sometimes we'll say 30 days or 30 days. The thing is if she takes an extra day, I get an extra day, and it worked out good. And it's always been good. But when she gets in a relationship, everything changes, and her boyfriends think they can change the way I'm in the picture, and it's not going to happen. Like when she was married to Taylor, I was the piece of shit dad, but I was the one always doing for my daughter. Now she's with my son. Now I'm another piece of shit dad, and I'm still the one doing everything for my daughter. I have a house. I have a full-time job I've been with for 14 years. I don't drop and date women and go live at their house. The only reason she has a house is because my son, grandpa, let them live in that house. I've been here 9 years in my house.
Let's talk about those issues. So you said you've been at your house for how long?
I've been here almost 9 years, 8, 9 years in the same residence.
How many bedrooms? How many bedrooms?
There's 3 bedrooms. 3 bedrooms.
And how many people live there?
There's 3 kids and 2 adults.
Does Kylie share a room or have her own room?
Kylie's had her own room since I've been single in this house. And she still has. She's had. Yes, I've been with Apple Construction since 2009.
Okay. Do you have any intent to move in the near future, or do you plan to stay in the area?
I'm staying in the area, but me and my fiance are going to be investing in getting a house this summer. It's just hard to find 4-bedroom houses right now on the market. I'm renting. So.
All right. Anything else you'd like me to know, sir?
I just want the safety. I'm all about the safety of my daughter. That's all I got to say. And I'll fight tooth and nail. Yeah, thank you.
Do you have any witnesses you wish to call?
At this time, no, because like I got all their names and numbers, but I didn't notify them that I had this today. So no, I'm unprepared.
I mean, this is your opportunity then to provide testimony in support of your position. But first, why don't you tell me what you are seeking as far as custody and parenting time?
Well, so I'm not trying to, Ken, like I want to do what Kylie wants to do. So if she wants to be at her dad's during the school weeks, like I'm totally fine with that. Ken has never been a bad parent. So, like, I just want what's best for Kylie. She's old enough now to decide what she wants to do. Like, I would like to have her week on, week off, like we've been doing, because anytime Ken gets upset with me, like he keeps her from me. The last time was for like 41 days, right before like we got that first court hearing. He gave her back to me, but before that, I didn't have her for 41 days. I just want to like just do the whole week on, week off, and if it happens where she wants to be there during the week, then that's fine with me too.
Okay. All right. So, man, this is then your chance then to explain to me what's been going on and why you want to have the situation you are suggesting.
Okay. Just like I said, I'm not trying to bash Ken. Like, I'm not trying to look like a bad parent or nothing. Like, he's been a good father to her, just like I've been a good mother. Like, I'd never sent her home in my underwear. I don't know why that's being said. I maybe kept Kylie from him once, like when we split up like years and years ago. But that's not in the best interest for Kylie to keep her from me. And every time he gets mad, that's what he does is keep her from me. And it's not healthy. And I have been, like he said in the past, I haven't been responsible. And I've been trying, like, I went through my divorce and Kylie was with me before my divorce. And then that's another thing he brought up was last year. I didn't have her for school. He had her for school last year. But the last like few years, I asked him to take her because of me going to a divorce. I didn't have a place to live. And I was trying to get back on my feet. And then I thought we would come to some kind of agreement after I got back on my feet that I would get Kylie back like normal times. And then the tornado hit and I lost literally all of our belongings. I was trying to like rebuild from scratch. And then we came here to live at Andrew's house. And I feel like I've changed a lot. Everybody's brought up that I'm still a drug user. I've been sober for almost a year now. I go to drug counseling classes. I go to I take drug tests. I don't even have to take them. Like I've been on probation. I'm already off of it, and I still take voluntary drug tests. Like I just want to what's best for Kylie. So if she decides that she wants to stay with her dad, that's totally fine with me.
All right, let's talk about some of the questions like I asked of Mr. Wood. So what is your current living situation?
So I live at Andrew's father's house. He does not live here. It's just me, Andrew, and my two daughters, Kylie and Allie.
All right. How long have you lived there?
Since before Andrew it's been a little over a year, almost 2 years now. So before Andrew got released last March, so the September before that is when I started living here.
What city are you in?
Mansalona.
Does that create any issues with you getting Kylie to school in Gaylord?
No, because Allie, I get Allie week on, week off, and I take her to school every day when on my weeks.
She goes to Gaylord schools also?
Yes. And with my job, I work 2 jobs. They work around my schedule to where I can be able to take them to school. And when they're here, I don't work. I really work during the day while they're at school, so that way they're not here. Like I'm spending time with them.
What are your 2 jobs, man?
I work at Family Fair here in Mansalona, and then I work at Great Lakes Trim. It's a factory job in Williamsburg. When the girls are not here on the weeks off, I work 50 hours there a week.
And when is it, what's your testimony as to when the 2 of you and Mr. Wood stopped living together?
Oh, okay. So I know he got a little off, but I think it's been like 8 because we split up when Kylie was 2 and she's going to be 11. So I think it's been about 9 years.
Okay, halfway off.
That's okay.
Since the breakup, what has the custody arrangement looked like?
Like I said before, like he said, he went through issues like I did. He was a single parent. So at first I had her for the first few of her school years. Then he's had her for the last couple of years because I was going through a rough time going through my divorce. And now recently, as the last few months, we've been doing the week on, week off.
He raised some concerns with you not taking her to doctor's appointments or dentist appointments or getting an appropriate care. Is that true or not true?
I have missed a couple in the past, yes, but recently I've been taking her appointments. So I took her actually 3 already this week for her pneumonia.
What is your plan housing wise in the future? Do you plan to stay at the residence you're at? Are you looking to move or make any changes?
We plan to stay here.
he made some comments about some testimony that she misses school when she's in your care. Is that true or not true?
Well, he said something about last year, but I didn't have her last year, so
Last school year, she was primarily with dad?
yeah.
Okay.
I mean, if you like you said, if he wants another hearing where we have to show proof of stuff, we can do that.
How long have you lived with Andrew?
Yeah, I've been living with him since March.
Is there anything else that you wish to say, ma'am?
I'd actually like to bring up about the other day, just so Ken knows what happened. When we left the court, we went out to the parking lot, and Andrew was talking to his adopted dad, and they were kind of arguing, and Ken's brother Roy was in the truck and got out and started saying stuff to Andrew. So that's the only reason why Andrew, they didn't even get into like an altercation. All Andrew did was go over to his door and shut it. And then we went to go pull out, and he had to pull little forks out of both the cars around the side. So we had to pull up forward a little bit and back out. I got a brand new vehicle. He did not hit his car. There's no marks in my car. I took pictures of the front of my car. Like, I would not let him hit that truck in my brand new vehicle. And if there was, so his truck is white and my Explorer is black. Like, if there would have been hit, there would have been a big mark. Like, and there's no white paint on my car. So I just wanted to explain that to him.
So you're saying that you were in the car and he did not hit the other car?
No. Even Kylie said that, and we didn't hit the car.
Okay. All right. Anything else you'd like to say, ma'am?
No, thank you.
All right. Mr. Wood, do you have any questions for this witness?
For her, no. Because the pictures that the cops took of the tire tracks going into my truck don't lie, so they can argue that when I'm taking them, I'm pressing charges over that, so we'll be in court for that. That's all I got to say.
All right, Ms. Dewey, do you have any other people you wish to call as a witness?
No, thank you.
All right, thank you. Mr. Wood, do you have any closing statement or argument you would like to make?
I just hope the court finds the best that's good for my child. That's all. I just hope the decisions are right and we're not here regretting it later.
Ms. Dewey, any closing argument or statement you would like to make?
Once again, I just like to say that Ken and his girlfriend have both been really good with my daughter, and I just want us to each have our own equal time. I just want what's best for Kylie. Whatever Kylie wants, that's what I'm best for Kylie.
When you've been doing the week on, week off, what day are you changing?
It's the same as Allie's. We do Friday to Friday.
All right. So where does Kylie go this Friday? With dad?
She was with her dad, yeah. She's with me right now.
All right. Anything else you'd like to say?
No, thank you, Your Honor.
And would you agree there's never been a prior order regarding custody of Kylie?
No, we just had a mediation. We pretty much have agreed on everything in the past. We had, like I said, little bits here and there where he kept her from me, but we usually get over it. And
okay, thank you. All right, so the parties are before the court following a custody case that was filed by Mr. Wood, which also included an ex parte motion requesting custody. That ex parte motion was denied. The matter was then referred to the referee. We had a hearing on October 4th, wherein we set this matter for a evidentiary hearing today. The parties have had a chance to testify. Neither party has provided any written exhibits or other witnesses to testify in this matter. So the court is restricted to the decision based on what is on the record of this case today. Being that there is no prior order, there's not need to be a showing of proper cause or change of circumstances. The court does have to consider whether or not there's an established custodial environment with either one parent, both parents, or neither parent. The established custodial environment is the environment in which the child looks for guidance and support. The parties have testified that they have essentially shared custody since their separation. They've made some changes at times as to how that looked, whether it was week on, week off, or primarily with one parent during a school year. But they have clearly both been actively involved and shared time with the minor child. Therefore, there's an established custodial environment with both parents, which would mean in order to disrupt the established custodial environment, a party would have to show that there's clear and convincing evidence that would support a disruption of that established custodial environment. The court then looks to the best interest factors in this case. I will review those one by one. The first factor is the love, affection, and emotional ties that exist between the parties involved and the child. The parents really didn't get into much about their own relationship with the child in this matter and things that they do with and for the child. But based on the testimony, I think certainly they both have love and affection for the child. They've equally shared in responsibility time with the child. So I would find that factor is equal. The next factor is the capacity and disposition of the parties involved to give the child love, affection, and guidance, and to continue the education and raising of the child in his or her religion or creed. Again, the testimony is that they have both at different times been the primary parent during the school year. They both have provided for the child. There was some allegations of the child missing school while in mom's care last year, which is inconsistent because their mom says that she was primarily with dad, but either way, there was no documentary evidence provided to indicate there was any issue with attendance in either parent's care. I think both parties have the capacity and disposition to provide Kylie with these needs. Therefore, I'll find that this factor is equal. The next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, and medical care. Dad has testified that mom has missed some appointments, but she's also taken the child to some appointments. Mom acknowledged that there was a time period where she did miss some appointments. That has changed recently. Both parties are employed and seem to be able to provide the child with necessities of food and clothing and make sure there's the ability to get medical care. Again, this factor does not look at necessarily which party does more than the other. It's just, do they have the capacity and disposition to provide these needs? And I think based on the testimony, they both do. I would find this factor is equal. The next factor is the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. Dad has had his residence for quite some time. He had a stable residence provided for the child in this matter throughout her life. Mom has had more moves than dad. Certainly, she has been at her current residence, though she indicated for a couple of years. There's been some changes in who resides at that residence, with Andrew Dewey now residing there since March. But she does plan to remain where she's at also. Dad has been at his residence longer, so I would find that this factor slightly favors the father, given the more stability in his living arrangement. The next factor is the permanence as a family unit of the existing or proposed custodial home or homes. Both parties indicate they plan to remain in the area, not make any major changes when it comes to moving. Both parties apparently have new relationships. They are a part of their family unit. I would find that this factor does not favor either party, and this factor is equal. The next factor is the moral fitness of the parties involved. This factor looks at whether or not there are any moral fitness issues that impact a party's ability to parent. Based on the testimony of the parties, neither party really presented any evidence regarding the moral fitness of the other party not being able to parent appropriately. Therefore, this fact. Next factor is the mental and physical health of the parties involved. Neither party indicated they have any concerns with their own health or the health of the other party. Therefore, there's no evidence to show that either party has a mental or physical health issue that impacts their ability to parent, so that factor is equal. Next factor is the home, school, and community record of the child. Again, as stated, Dad indicated there was some attendance issues in mom's care. Mom does dispute that. There is not any documents that support this matter either way, nor any documents that support the child struggling with one parent over the other parent in school. So given the lack of evidence submitted, I would find this factor is equal. Next factor is the reasonable preference of the child. If the court considers the child to be of sufficient age to express a preference, I did meet with Kylie prior to this hearing. I do believe she is of sufficient age to express a preference, and her preference is taken into consideration in this decision. The next factor is the willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. Neither party really attacked the other parents for trying to disrupt their relationship with the child. Mom indicated there was a period of time where the child was withheld, but really there's no strong evidence to indicate that either party is trying to destroy the relationship that the child has with the other parent. Mom's testimony was that she, in fact, would actually, if the child indicated she wanted to stay with dad during the school year, she would likely allow that to happen. And the parties have functioned for a long time without an actual custody order, and they've continued to essentially share custody and make some changes along the way. So they both have allowed that relationship to continue to exist between the child and the other parent. So I find that factor is equal. Last factor the court is to consider is domestic violence. There was no testimony of any domestic violence between the parties when together. Mr. Wood did indicate that there was some domestic violence between Ms. Velding and Mr. Dewey. However, there was no direct evidence of that provided or any documents or any non-hearsay testimony provided to support that. So I would find that factor is equal. When considering the sum of the best interest factors, and in particular how the parties have handled this matter since they've been separated for a long period of time, it is the court's recommendation that the parties share joint legal and joint physical custody, that the parties have a week on, week off parenting time schedule. The child is currently with mom, so dad's parenting time would begin on Friday. Is there a time that the parties exchange child, or how do you handle the Friday exchanges?
School.
Okay.
It's whoever,
So
I pick her up on my Friday, and then Caitlin picks her up at school on the following Friday.
So during the school year, the party whose parenting time starts on a Friday will be in charge of picking up the child from school. In the summer, how do you handle the parenting time exchanges?
We usually do, last summer, I think we did 2 weeks on, 2 weeks off. And like, she gets her for Mother's Day. I always get her for Father's Day. We usually switch, like if she gets her 1 year for Halloween, I get her the next year. Christmas, it used to be Christmas Eve, Christmas Day, but I like to switch. I already talked to her about like switching it up where I get her Christmas Day 1 year and she gets her the next year, vice versa.
I think he was asked about the ride, Ken, for like his summers.
So we'll start with summer. So Miss Dewey, he indicated you guys have been doing kind of a 2 week on, 2 week off. Is that something you're interested in, or something
in the
different?
summer? Yeah, that's fine.
All right. So the parties will do 2 weeks on, 2 weeks off in the summer. Would you exchange on Fridays still?
That's fine with me.
At what time on Fridays in the summer?
Ken, if it's okay with you, I always drop off or pick up Allie at 9 a.m. on Fridays. If there's no like school, or in the summertime, it's 9 a.m.
Yeah, that's fine.
All right, so 9 a.m. on Fridays in the summer. The parties will, so he indicated, Ms. Dewey, that you guys have kind of had your own holiday schedule. Are you okay with continuing to say that the two of you just share holidays as agreed, or do you want a set schedule?
We can do it. I mean, we've always been pretty good about the holidays together.
All right, so we'll say share holidays as agreed.
Yeah, and he, like I said, he can have her for the Christmas because last year there was a big snowstorm and I had pretty much had her all Christmas.
There will be a child support recommendation prepared based on the custody arrangement and overnights. I don't know if the court has sent you those forms yet to fill out, the financial forms.
Your Honor.
Yes.
Yeah.
I have a question. When we split up, we always I agreed never to make him like pay child support or anything. Is there any way we can still do that?
There is a way, but step one will be we have to issue a child support recommendation, and then if the two of you look at that and want something different, you file an objection, and we would address that in court.
Okay.
Have you filed, Ms. Dewey, your financial information with the front of the court?
No, I have not.
All right. So if you have not filed that paperwork in front of the court, we can send you that paperwork again if they haven't sent it yet. And then I would just say the parties have to complete that financial paperwork within 21 days so a recommendation can be prepared.
Okay.
Okay.
I'm going to give this recommendation interim effect, which means it would take place immediately. However, the parties do have the right to object to the recommendation if they want. That information will be provided in the paperwork that is sent to you. Do you have any questions, Mr. Wood?
No.
All right. Ms. Dewey, do you have any questions?
No, Your Honor.
All right. Thank you both for appearing. That does conclude this matter.